Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 142 of the podcast. Thank you for listening as we continue our quest to episode 200, not too so distant future. Very excited today. I have my beautiful wife as my live studio audience. Good morning.
Thanks.
Yeah. So I know I'll talk to you today in the last few weeks. I have a couple of guests, and I'm excited about the podcasts that are coming up. So today I decided to go do one by myself. And I've talked about trials and what happens to trial and trial preparation. So say you have a case and you have gone through your depositions already. You have deposed, your deposition has been taken. You have deposed the opposing party. You have deposed witnesses. You have done written discovery, requests for productions, interrogatories, and requests for admissions. You have subpoenaed third-party witnesses already, and you have all the documents together. You have gone through motion practice. You have more cross motions for summary judgment that have been denied, and you have attended mediation, and mediation has resulted in an impasse, meaning that you did not settle the case. So trial is inevitable in this case, that you say the only way this is going to be resolved is going to trial, and you're aware of the cost involved, and you have advised your attorney, we rather take our chances in court than settle this case, or perhaps the other side is not willing to settle, and you're willing to try to get it resolved, but they rather go to trial. And as I mentioned to you before, when you go to trial, you're in essence telling the court, we cannot solve this by ourselves. We rather have you solve it for us, because you're giving your problems to a jury that, for the most part, does not want to be there, or to a judge that has a lot of different cases, and then to manage. And the judge will make a decision. The judge will dedicate a number of days to your case exclusively, and the judge will render a decision. That is what is called a bench trial. So when you are getting ready for trial, that's the real work begins there. You have done everything you can to settle it. You have all the information. You have thousands of pages of documents. You have, several other thousands of pages of deposition transcripts that your attorney has to go through, and you'll have to go through to prepare as well, including witnesses. You might have an expert witness as well that might be part of the case. So you're ready. So all that has to be organized now into a format that makes sense for the court. So one of the things that we have to do, one of the reports that we have to prepare for the court, for the judge, is what is called a joint pretrial stipulation. And we're going to talk about that today. What is a joint pretrial stipulation? What is contained in that stipulation? And how important is this document for your trial? So a joint pretrial stipulation is exactly what it states. You have it's an agreement in essence. This is something that you have to work with the opposing attorney. So if I'm plaintiff's counsel, I got to work with the defense counsel in preparing this document, and the court requires us to work together in preparing this document. And if we have disagreements as to certain aspects of the document, then we need to let the court know, and the court will decide one way or the other. But our job is to make it as easy as possible for the court, for the judge in this case, to really have a good roadmap of what the actual case is going to look like, and what is going to what the case is all about, but also how the trial is going to operate. It's basically the roadmap or the outline. So why is this important? Because what is in the trial and the joint pretrial stipulation, it is binding. You're making an agreement with opposing counsel that we agree on these terms, and this is what the court can rely upon to move forward. So what is in it? Let me go into more example, okay? And one of the objectives here is to really eliminate surprises. Trial, especially in the context of business litigation, it's not like you see on TV, you have a surprise witness, you have a surprise exhibit. There are no surprises when you have in a business litigation context. So in this case, we have to put everything in the stipulation for the court to rely upon. And if it's not there, very likely you're not going to be able to bring it up at trial. So what is included in this joint pretrial stipulation? The first thing is the statement of the case. As simple as it sounds, sometimes we disagree on this particular, just telling the judge what the case is all about. Because the judge will read the stipulation. First thing the judge will ask, can I have the joint pretrial stipulation? And the judge will read that because that is the synopsis, the summary, what the case is all about. Obviously, depending who's writing this joint pretrial, this statement of the case, we will make the spin based on the most favorable to our client. So, the plaintiff will write it more towards, that the plaintiff damages or what the defendant did. And the defendant will write it in such a way that, hey, you know what, this is what this case is all about, but in essence, we're not at fault. So the attorneys kind of come up with language and we begin to negotiate about giving the judge a generic explanation of the case without really trying to spin it one way or the other. Or in the case like that, we just write we write statement of the case from the plaintiff's side. This is the position of what the statement of the case is. From the defense side, this is basically our statement of the case. The judge can read both, but in essence, we'll have some common themes, but we'll basically have our spin toward most favorable to our client to give the judge kind of an idea of what is coming and why we have this trial. Stipulated facts, but this is very important. And I just had recently a situation that the stipulated facts done by a prior attorney before I took over the case were not favorable to our client. Stipulated facts, exactly what that means. Things that are already agreed upon as facts by the plaintiff and the defense. And we try to have something, we talk to opposing counsel and we try to get some stipulated facts that are favorable to our clients. That's what we do. They do the same thing. We say, no, that's not a stipulated fact. We disagree on that. It is important that what goes into a stipulated fact is actually agreed upon, and it is not, that is something that is 100% factual and accurate. There's no disagreement of it. And for instance, in a breach of contract case, a stipulated fact could be that the parties agreed that this contract was signed by the parties and is a valid and enforceable contract. Okay, that could be a stipulated fact if there's no dispute as to the contract itself and the content within the contract. You can agree on the dates, you can agree on the signatures. That's one stipulated fact. So you go into the various, another stipulated fact would be that people that signed the contract had authority to do so and sign on behalf of the corporate entities. So that could be a stipulated fact. I'm just giving you examples. Every case is different, of course, but the idea is that you have a stipulated fact, it has to be clear that there's no dispute as to that fact. Then once you go through that, and it's usually there's a lot of communication between defense and plaintiff counsel during that time period that you're preparing for trial. Your attorney's going to get to know the opposing side very well, and vice versa. At a trial, not long ago, which I was talking to them almost every day. Every other day, we had Zoom calls going through some of the items in the pretrial stipulations and some amendments we needed to do to it to prepare for trial, coordination of exhibits, who was going to bring one to the courthouse. There's a lot of things that go behind the scenes that you're not aware of, that your attorneys are involved in the preparation of the trial. It could be something logistical as like, hey, so we don't duplicate the copies to bring to the judge. What are you going to bring? And are you going to bring out a visual? So we both hire a company to bring AV equipment to the courthouse. So those things can be coordinated so you don't duplicate. And you can also have more efficiency that way. So then once you have the stipulated facts that you agreed upon, then you go into facts, issues of facts and law. Those are issues of facts are the unstipulated facts, the facts that you disagree on. And from the plaintiff side, these are the facts that we disagree on. You have that list, defense side, or it could be joined together. This is what we disagree. And then the issues of facts and law, the issues of law. In the case, issues of law, for instance, the defendant breached the contract on such and such a date. That's just one example of an issue of law. Is the plaintiff entitled to damages as a result of the plaintiff suffered damages as a result of the defendant's breach? That would be an issue of law. Does the defendant was unjustly enriched by the services or the funds provided by the plaintiff? That could be an example of a issue of law. Did the defendant commit fraud and inducement upon the plaintiff when she presented the contract? She represented certain facts to the plaintiff. So there you get my gist that you basically have all those issues that the court has to rule upon. If it's a bench trial, those are the decisions the judge has to make. If it's a jury trial, that goes into then the jury instructions. But that gives the idea to the judge, okay, these are all the decisions that I have to make as a judge in order to render a ruling one way or the other after the presentation of the case. So once we agree on the issues of facts and law, then we go into our witness list. This is critical. The witness list is very critical. By now, if you're already at this stage of the case, you should have deposed all the witnesses that you intend to bring a trial. If you are at a stage that you're doing a pretrial stipulation and you have not deposed a witness, you might have an issue here because by that time, most likely discovery has been closed. There are deadlines, and I think I spoke before about a case management order, which has a number of deadlines throughout the period to make sure that you have closure and push towards trial preparation. So by this time, you should have everyone that you intend to bring to trial deposed. Now, if it's a friendly witness that you bring in, you don't have to depose your friendly witness. It's the responsibility of the other side to request to depose this individual. And usually by that time, they know who you want to bring because either it is done through initial disclosures, anyone, all potential witnesses that you want to bring. So that's done at the beginning of the case. Who you want to bring in and who you anticipate and what knowledge do they have about the case. And you list everyone. You usually ask a second time. We ask in discovery interrogatories. Please name any and all individuals or entities who have knowledge about this case and what knowledge do they have. So we include that as well. Anybody that you've spoken to about this case outside of your counsel, we try to go through questions to make sure that we have covered our bases, to make sure that all potential witnesses have been identified. And that's done early on in the case. Fast forward, you're close to 10 or 12 months later into this case, and you're at your pretrial stipulation stage that your attorney is listing all potential witnesses, or witnesses that you anticipate bringing a trial. Now, let me make a distinction here. Just because they're in the witness list does not mean that you're actually going to call them. You may call them, you may not. But you better err side of caution that if anybody that you anticipate bringing in to trial to testify, that you include that person in the witness list, or the corporate representative of the company in the witness list. Why is that? Because if that person is not in the witness list, you're not going to be able to bring the person in to testify on your behalf to help your trial and to support as evidence of trial. I repeat that. If the individual or the company representative is not in the witness list, you're not going to be able to bring that person in to trial for the most part. And I say for the most part because there are always exceptions to every rule. If there's some newly discovered evidence and for some reason you discover a brand new witness that could help your case, there's a mechanism for that, which might be you can call opposing counsel first and say, listen, we find about this witness just now. I need to take this person's deposition. Okay. I need to have an extension to the discovery to take a deposition. You can to do a cross-examination as well, of course, or depose the witness, but I need an extension. And if the opposing counsel disagrees, say where discovery is close, you can go to the court and ask permission to depose this witness and before your deposition, before the trial. So there are ways to doing that, but what is important here is that all witnesses that you anticipate bringing a trial should be listed in the witness list. It's also important that if you're going to bring them in, unless they're people that you know that you can rely upon and say, listen, we have this 3-week trial period. Are you going to be in town? So yes, okay, so there's a likelihood that I'm going to go to trial sometime within that 3-week period. I'll know about, say 48 hours before, sometimes 24 hours. So I want you to be available. I'm going to issue a subpoena, but if I call you, I need you to come in. So there's a way to do that, but importantly is that your witnesses also be available to testify and willing to go to the courthouse to testify. Clearly, you can compel them through a subpoena, but you want to make sure they're available. And if they, by any chance, they're not in town, you can ask the court with a cooperation for opposing counsel to have that witness be able to testify via Zoom. So there are ways to do that as well. But the witness list is essential, very important. So it's important that everybody is in the witness list. Now, let's talk about the next thing that you're going to add into the joint pretrial stipulation. And by the way, when I say you, it's your attorney. If you are doing this on your own, as I mentioned before, you're at a tremendous disadvantage. So it's something you work with your attorney with. But my recommendation, if you're going to go to trial, have an attorney handle it for you. But you can absolutely be part of it, understanding that you got to read the pretrial stipulation. And in fact, in this case that I reviewed a few months ago, when I asked the client, I said, have you reviewed the pretrial stipulation that your prior attorney prepared? What is that? That creates a problem because the person does not know, the client did not know what that attorney agreed upon. So it's important that you get involved with your attorney and review the pretrial stipulation to make sure that everything that is agreed upon, you agree to it, and all the witnesses and exhibits that should be included are included. So let's talk about the exhibit list. Before I go there, let me talk back to witness list. So you have your witnesses listed in the witness list. So at trial, you may decide not to bring them. You may decide to bring one or two because depending how the case is going, you may not need that particular witness. So you don't have to call that. You're not obligated to call everybody in that witness list if you feel, your attorney feels that perhaps that witness is no longer needed for whatever reason. But it's important to have that witness listed there. Exhibit list. So this one is very important. And exhibits can be voluminous. I had a case recently that we're dealing with 2,000 exhibits. And so it could be talking about email communication, text communication, a lot of contracts, a lot of documents. But emails and texts can take a significant amount of exhibit time and space. So every exhibit every email that is going to be used or anticipated to be used at trial has to be in the exhibit list, and that's to be pre-marked. So the attorneys have to work together and find out these are the list of exhibits that we plan to use. So a way that we can become efficient, especially with email communication or text communication, that it is an exchange most likely between two parties. So we can agree that certain exhibits will be joint exhibits. And what it does in this case is that it really saves time of us introducing the same exhibit again. If we can stipulate, hey, the contract, which is the subject of the dispute, is a joint exhibit. And it is admissible evidence, meaning we're not going to be challenged or objecting to that, the admissibility of the document. We can agree that the email communication that they had between the parties, are joint exhibits because we both will be using them for our purposes. I might be using it for a direct, I might use it for a cross, and vice versa. And we also can agree that these are admissible evidence because it's admissions by the parties. Business records as well, banking statements, all that, financial statements, all that becomes part of the exhibits, and every one of those has to be labeled and marked, pre-marked for the court in an index, so that way when we talk about an exhibit, it's already pre-marked to make, we don't want to take the court's time pre-marking exhibits. So we're required to do all that. And the first thing we got to do as attorneys is, what exhibits do we agree that we can use? And that's the easy part. We agree in these exhibits. Then which agreements, which exhibits we object. There might objection to some exhibit that I might use, and vice versa. Those we list and say, okay, we object. Plaintiff intends to use the following exhibits. Defense objects to these exhibits on the following reason. Could be irrelevance, could be relevance, could be hearsay, could be prejudice, could be a number of reasons why an exhibit can be objected to. And those will be set aside, and the court can handle them in a pretrial motion, in a motion for limine, which we'll talk at another time, or it can be done through a hearing prior to the trial. So you have your witness list, you have exhibit list. Another thing is that you may have a list over 1,000 exhibits on that page. It does not mean you're going to use each and every one of them. But if you do not have a exhibit marked, pre-marked, and included in the pretrial stipulation, very likely you're not going to be using that exhibit at trial. It's not going to be admitted. Also, if you do not object to an exhibit through the pretrial stipulation before trial, or raise that objection before trial, and raise it at trial as a surprise to the opposing side, the judge will ask you, did you raise that objection beforehand? The answer is no. Very likely the judge is going to admit that exhibit into evidence because you did not raise that objection timely. So, and this is all behind the scene that the attorneys work together. Now, some things that has happened here is that sometimes you're preparing for trial, you find a document that perhaps was not produced. It just, slipped through the cracks. We're dealing with a lot of documents, a lot of emails, and you let opposing counsel know in this case, hey, just to let you know, I just found this. I intend to use it. Here it is. Do you have any objections? So anything that has not been produced before, the opposing counsel needs to know beforehand, so that way there are no surprises. You got to bring that up front. It happens. It happened to me when opposing side say, listen, I found this email. I want to send it to you. Do you have any objections to we use it? I look at it. No, you can use it, but I'll use it as well. As long as both of us can use it, we're okay. Those things happen. And when in that case, you do a supplemental exhibit list. And sometimes we do 3 or 4 supplemental exhibit lists. Now, probably won't have time might do this in 2 parts. But I want to talk to you about why it's important, the pretrial stipulation, and what happens when you prepare this. Mm-hmm. What happens in pretrial stipulation is that you basically see a snapshot of your case, all in a number of pages. You see the summary, you see the plaintiff's position, you see the defense's position, you see all the witnesses, you have the deposition transcripts of your deposition transcript. You should also have the other side's deposition transcript. You have the witness's deposition transcript. You have your entire trial in a binder in a set of documents. So there you'll see how strong your case, your strengths, your weaknesses, areas of vulnerability, areas of strengths, because there are really no surprises at that point. You have everything. At that point, when you go to trial, you are relying upon the skills of your attorney to present the evidence, how you will testify at trial in a live setting. How will your witnesses, are they going to show up? And how will they testify at that time as well? And in many cases, when people look at that, they say, this is the pros and cons, and this is my risk going into trial. And what has happened in the past in many cases is that people look at this and have an honest conversation with their attorney and said, what are my chances? What am I looking at here? What are my risks? And it's a good conversation to have at that point because you're not at trial yet. You're yet not at trial. But you see everything that is going to go in, and it's about how the presentation is going to be made, how the presentation is going to be made to the jury or the judge. And at that point, the case is out of your hands as it has to your attorneys, and also the judge or the jury. Mm-hmm. So what happens in this case, people make an analysis and say, perhaps we should talk about potentially settling. There's nothing wrong if you decide to have that conversation, even at this late stage of the case. There's nothing wrong with it. Because as I mentioned to you before, and I think we had Matthew Fornaro as our guest, talking about mediation and arbitration. If you settle a case, if you decide that, I'm not going to roll the dice, going to trial, you do it on your own terms. Because the other side is making the same calculation that you're making, because now you have it all in one neat package, which is the pretrial stipulation. You have it all together. It's not like randoms, exhibits in different places. You don't have the position transcript, different folder. Everything is together at once. And you can see, okay, if this piece of evidence is used against me, how is this going to affect my case? Or do I have this piece of evidence that actually is going to help my case? So at that point, there's nothing wrong with having the honest conversation with your attorney about, hey, listen, if I settle the case at this point, how can I settle it? So you can even settle it as you're selecting your jury. You can actually settle it after the presentation of the evidence before they actually rule. But remember that every stage of the case, as you go further and further, you're losing that opportunity to resolve the case on your terms versus somebody else's terms. But the pretrial stipulation is it's a document that helps you. Number one, it's required by the court. Number two, it also helps crystallize and make it clear how this case is going to be tried. Another aspect of the pretrial stipulation is the number of days that the case is expected to be tried. It could be a 3-day jury trial, 4-day jury trial. It is important that your attorney and the opposing counsel really have a realistic assessment of how long the case is going to take. If you don't properly estimate the number of days, then the judge is going to either rush you through the case, which is not a good idea, might give you less time for opening and closing, or then the case has to be continued for another time, which has happened to me a number of times, not because of the lack of the estimated times, because there were some unforeseen circumstances with the court. The judge was not available. But when the case gets continued, you in essence have to do this all over again next time you meet. In the meeting, the trial continuance could be, if it's a non-jury trial, could be the following month. So in essence, you are to prepare again for the same trial to continue it. If it's a jury trial, if it's continued, it might be for maybe a day or so because you have jurors there that are being convenienced. But you have to make that assessment how many days. All this is behind the scenes. And the reason I mentioned that is because you don't know how much time it will take to do this until you get that bill from the attorney. And it could be substantial because of the amount of work that goes into it. So I hope that you had a kind of a good introduction to what a joint pretrial stipulation is, the importance of it, the importance of having the correct stipulations, the agreements that are actually agreements, making sure that you have the areas that you disagree on and the areas of law that are to be decided upon at trial, the importance of the witness list, the importance of the exhibits that as list as well, that everything is accounted for, and also the number of days that the trial will take. Hope this version was helpful. If you have any questions about any of the topics we've spoken about at the trial, please send me an email. My email is rich, R-I-C-H, richsierra.com. If you want to check out our legal services, you have any legal issues that we might be able to assist you with, my website is FloridaSmallBusinessLegalCenter.com. Again, FloridaSmallBusinessLegalCenter.com. My phone number is 866-842-5202. If you want to watch the video of this podcast, we're at youtube.com/@RichardSierra. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.